Supreme Court of India Deepak Kumar Shrivas and another versus State of Chhattisgarh and others decided on February 19, 2024 SCC Online SC 158 Facts of the case. The appellant made a complaint dated April 6, 2021 to the collector, alleging that the respondent number 6, Rajkumari Maravi, had allured the appellant that she would secure a job for his brother Raj Kumar Shrivas as she had good contacts with higher officers and demanded substantial amount for doing this favor. The appellant got allured and paid Rs 80,000 later on, deposited about Rs 20,000 and odd in different bank accounts, details of which were provided by respondent number 6. When nothing happened and no job was provided to his brother, he approached the respondent number 6 for returning the money paid by him, upon which she threatened him of false implication, and later on she stopped responding to his calls and started avoiding him. The station house officer made detailed inquiries. Appellant and respondent number 6 to produce the relevant documents and also the details of the call records and recorded conversations. They failed to provide any such material. Accordingly, it was recommended that the complaint deserves to be closed. Later on, respondent lodged FIR against the appellant on July 27, 2022. In this inquiry it was found that both parties have made allegations against each other of taking money for providing a job. High Court dismissed petition for quashing of FIR. Finding of the court. A reading of the entire material on record clearly reflects that it was totally an unlawful contract between the parties where money was being paid for securing a job in the government departments or private sector. Apparently, a suit for recovery could not have been filed for the said purpose, and even if it could be filed, it could be difficult to establish the same where the payment was entirely in cash. Therefore, the respondent number 6 found out a better medium to recover the said amount by building pressure on the appellant and his brother by lodging the FIR. Under the threat of criminal prosecution, maybe the appellant would have tried to sort out and settle the dispute by shelving out some money. Prima facie, the conduct exhibited by the parties involved appears tainted with suspicion, casting a shadow over the veracity of their claims. The report from the previous inquiry reflects a convoluted landscape and unveils a trail of unethical, maybe even criminal, behavior from both parties. The unexplained inordinate delay in bringing these allegations to the police's attention despite knowledge of previous inquiry, raises even more doubts and adds a layer of skepticism to the authenticity of the claims. The facts stated, as well as the prior inquiry, reveal a shared culpability between the parties, indicative of a complex web of deceit and unethical transactions, where even civil remedies may not be sustainable. Thus, the object of this dispute, manifestly rife with mala fide intentions of only recovering the tainted money by coercion and threat of criminal proceedings, cannot be allowed to proceed further and exploit the time and resources of the law enforcement agency. It becomes imperative to state that the police should exercise heightened caution when drawn into dispute pertaining to such unethical transactions between private parties which appear to be prima facie contentious in light of previous inquiries or investigations. The need for vigilance on the part of the police is paramount, and a discerning eye should be cast upon cases where unscrupulous conduct appears to eclipse the pursuit of justice. This case exemplifies the need for a circumspect approach in discerning the genuine from the spurious and thus ensuring that the resources of the state are utilized for matters of true societal import. We are of the view that such criminal prosecution should not be allowed to continue where the object to lodge the FIR is not for criminal prosecution and for punishing the offender for the offense committed, but for recovery of money under coercion and pressure, and also for all the other reasons stipulated above. Appeal is allowed, FIR is quashed.